Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. We are talking today about the new proposed regs for the waiver of the 10-year bar and some issues regarding that. So, uh, there's some questions that come to mind in regards to this. For example, how would the proposed process affect the existing standards related to unlawful presence and the extreme hardship standard? Well, it doesn't. It doesn't affect it at all. The proposed process retains all of the legal standards and policies related to unlawful presence determinations and establishing extreme hardship. So it would simply provide for processing of these waivers inside the United States instead of abroad. And while I don't want to minimize that, by being able to process it inside the United States, it does two major things. One, it doesn't separate the family before the waiver is actually decided upon, and two, it gives a much better route in which to submit these waivers. Now, will individuals who receive the waiver be able to adjust their status without leaving the U.S.? Well, the answer is no. The visa process itself is not changing. Basically, what's happening is individuals who receive a provisional waiver would still be required to depart the U.S. To apply for their immigrant visa. And of course, this applies to people who do not qualify to adjust status in the U.S. Now, another question, is everyone who has accrued more than 180 days of unlawful presence subject to a 3 or 10-year bar from entering the U.S.? The answer is yes. However, there are exceptions where some foreign nationals do not accrue unlawful presence. For example, if they're under 18, if they have valid asylum applications, if they're victims of crime. There's certain exceptions in regards to that. So those are some of the questions, and we'll get more in the coming videos.